Good evening, everybody. Thank you so much for turning out in inclement, cold, both actual weather and political weather to discuss the very timely research that we have participated in as a panel on EU and UK migration and asylum law post-Brexit. So promises that sovereignty would be regained, immigration and asylum controlled, and national identity reasserted was central, as many of you will know, to the Brexit referendum campaign of 2016 and the ultimate decision to leave the European Union. In debates around EU membership, migration for labour, to study, to reunite with family, and for protection reasons were frequently conflated and portrayed as, in general, as being out of control. Post-Brexit, these issues remain at the centre of political debate and legal change, as we saw just yesterday, but not just in the UK, also at the EU level and across European states. So in this seminar, the European Studies Centre and the Refugee Studies Centre have come together to bring you a constellation of stars in EU scholarship to map pre- and post-Brexit legal developments, and hopefully when we have shared our research with you, to have a conversation or a debate about future directions. So full biographies of all of our speakers are online. For those of you who don't know me, I am Cathryn Briddick, and I'm a fellow here at the European Studies Centre. To my left is Professor Steve Pearce from the University of London. To my right is Professor Cathryn Barnard from Cambridge and Dr. Fiona Costello from Cambridge. All of the research that we're going to be talking about is going to be published next year in an OUP edited collection entitled Law Unbound, which is edited by Professor Paul Craig and Dr. Vivilia Velt. So hopefully you'll have a chance to read this, should you be so interested in the future. Now, we were going to be joined by our good friend and colleague, Professor Cathryn Costello, but she was unable to travel this evening. So I'm going to do my very best to present an hour chapter, which is on asylum first, for around 20 minutes. I'm then going to invite Dr. Fiona Costello to discuss migration second, for around 20 minutes. And then Professor Steve Pearce will go third and discuss immigration. And after that, we'll open up for a broad conversation. Thank you very much. So if I could have my slides. Thank you. So I introduced the seminar by talking about sovereignty. And sovereignty myths, I think, are at the heart of, I would say debate, but perhaps we can come back to what debate it is in the question and answer session, but to political and legal contestation in relation to asylum and migration. So during the referendum campaign, as I have said, there was both populist, sovereigntist and racist rhetoric in which asylum was being portrayed as something that the UK no longer had the ability to exercise control over. And that was empirically and legally incorrect, as many of you will know. Empirically, and following the crisis of protection in 2015, whilst large numbers of protection seekers did travel within the Council of Europe and to the European Union in search of protection, comparatively few sought entrance to the UK to claim asylum here. So whilst campaigns around Britain's exit from the EU often displayed images of people predominantly displaced in the war in Syria, people who were refugees, walking across Europe in search of protection, the UK did not have a large part to play in the response to those who were fleeing a war in which crimes against humanity and other forms of ill treatment were prevalent. At the same time, during the Brexit debate, there were concerns around Turkish accession, which was entirely misplaced, and references to the large number of people who'd come to the UK to work following the accession of states in Central and Eastern Europe. Again, legally, these matters were always subject to British control because the UK had secured an opt-out in relation to the common European asylum system, and the UK itself chose to grant access to the labour market on an almost unconstrained basis to those who came from Europe, as Fiona will say. So this idea of being out of control was not correct empirically in terms of the numbers of people coming to the UK, and it wasn't correct legally in terms of Britain's role in the common European asylum system. I will explain a little bit more about how that works and the UK's role in it in a moment. The starting point for any discussion around asylum then, both when the UK was a member of the EU and now, is actually international law, and in particular the 1951 Refugee Convention and other human rights instruments which protects individuals from refoulement, so forcible return to a situation where their life or freedom would be threatened. The UK is part of an interlocking set of multilateral treaties, all of which safeguard in different ways and to different extents the rights of people who cannot be returned to their countries of origin because they face certain forms of serious harm. Now, the UK has chosen to assume all of those obligations. So essentially, there were two sovereignty myths, I would say, at work here. One, that the UK was out of control in relationship to its route with Europe. And secondly, that UK had somehow had these obligations foisted upon them when they in fact had chosen as an exercise of sovereignty to assume. So I just want to say a couple of words about the common European asylum system. And because Cathryn Costello is with us, we'll get the questions, I'm going to direct them at my much more learned colleagues. Essentially, initial cooperation in the EU in relation to asylum happened outside of the treaties. And there were two processes that, broadly speaking, I want to highlight. The first one was mobility for insiders. So if you were a European citizen or the family member of a European citizen, you were able to move increasingly freely. However, this freedom was secured by the immobilization of outsiders, both at the EU's external borders and internally in terms of a lack of recognition of statuses granted by other states. Now, the Common European Asylum System, as many of you will know, is a system of directives moving to regulations which have at their heart international treaties or a purported adherence to international treaties, including the Refugee Convention, including the European Convention on Human Rights, CEDAW, and the Istanbul Convention. But there are a number of ways in which European directives improved the position of refugees and others in need of protection, by adding precision to the question of who is a refugee, for example, and also attempting to establish some form of common standards for refugee recognition across the EU. So there are a number of phases of the Common European Asylum System, which I won't go into, but crucial to it is that the UK participated in these phases in a very partial and selective way. So we opted in, for example, to the first iteration of the Qualification Directive, and afterwards we didn't. Interestingly, we did always opt into those parts of the EU that were concerned with the return of individuals to the first country that they had arrived in. So those regulations that pertain to, for example, fingerprinting individuals and returning them by something called Dublin simply to the country that they arrived in. And this is really important when we get onto the Rwanda deal and post-Brexit developments. So the EU asylum system developed along these phases. There was a crisis of protection in 2015, which saw Aegean Islands essentially being turned into detention-focused deportation camps, where you have a series of cases at the European Court of Human Rights characterising conditions in those camps as being inhuman and degrading. But as I said, the UK is participating in this to a very limited extent and is not bearing the brunt or is not sharing responsibility for those who are displaced to and within Europe. Post-Brexit, then what did we do with the control? Well, in the chapter that I'm drawing on, I characterise post-Brexit developments in terms of three phases: distortion, repudiation, and potential reset. Distortion happened with a piece of primary legislation called the Nationality and Borders Act that purported to bring the Refugee Convention or parts of it into domestic law, but actually reinterpreted it in a number of key respects in ways that were not protective. Notably, it also ramped up the criminalisation of asylum seekers, making it almost impossible for individuals who have been compelled to travel irregularly by boat, for example, to have defences to criminal proceedings, even in cases where they're refugees. The second phase I characterise in terms of a repudiation of the UK's international legal obligations to those in need of protection. UNHCR at this point actually characterised the Illegal Migration Act and the attempts to send people to Rwanda as the extinguishing of the right of asylum in the UK. So many of you will remember the failed attempt of the previous government to deport asylum seekers to Rwanda to have their claims for protection determined there. As part of that plan, there was a raft of legislative moves which aimed to make it impossible to have your claim determined in the UK, and which essentially held people in a legal limbo. It's one of the reasons why there is a backlog still now in terms of protection seekers. So claims were not determined, individuals were held in very poor conditions, and as you all know, over £70 million was spent and no one was sent to Rwanda. 4 people went voluntarily. We don't know what's happened to them, but one can assume that they may have returned to Europe or the UK. The final phase is with the new Labour government. Now, I just want to say that writing about immigration now is really hard. Elsewhere, I've said it's like shooting at a moving target. We finished writing this chapter at the end of the summer, and so we understand the final phase with the new Labour government as being a potential reset, but one to formative cruelty and instability. And I think we can get on in the question and answers to the announcements that came yesterday. But one of the first things that the new Labour government did, so Keir Starmer, his first press conference was to abandon the Rwanda scheme and to announce that asylum processing was going to happen in the UK. Since that time, however, we've seen things like the deal with France, the one in, one out, and this instrumentalization of people between Calais and London. So we can get on to what kind of reset we're at, potentially, in the questions. Now, this is the bit I'm going to evade as much as is possible. So within the EU post-Brexit, there were also significant changes, in particular with the EU Migration and Asylum Pact. The raft of legislation that came in the first and second phases of the Common European Asylum System is being replaced in ways that are of quite significant concern. Now, I'm not going to go into the misery because it's thousands of pages, as you can see on the slide in front of you. There are 2 things I just want to highlight. First is the Returns Directive and associated procedures which purport to excise territory from the EU in a, I don't want to say it's a legal fiction, because that has specific meaning, but in a way that denies the fact that protection seekers have actually arrived in the EU and tried to hold them, again in a kind of legal limbo, in order to secure their fast processing and return. And so this accelerated procedure is going to apply to individuals who travel irregularly and perhaps are rescued in search and rescue operations or who present orders. The second thing I want to talk about is an attempt to remove individuals from the EU without providing them with proper what's called suspensive appeals. Now, this is something that is almost certainly, both of these policies are almost certainly going to be challenged at the Court of Justice of the European Union, because one of the foundational commitments of the Common European Asylum System is respect for international law. And one of the key roles of the Court of Justice of the European Union is to ensure that EU law is interpreted in line with, for example, the Charter on Fundamental Rights. And so a number of these policies regarding detention, removals, truncated appeal rights, or an inability to have an in-country appeal are profoundly worrying from a rule of law perspective, because they're about setting up, as far as I can see, challenges at the Court of Justice of the European Union. And that has both political and legal consequences. So I'm coming to an end, you'll be pleased to know. And in doing so, I'm going to talk about 3 areas, I think, of convergence and divergence between the UK and the EU in relation to all of these changes. My starting point here, and it's one that I think is always worth returning to, is that a wealth of empirical and other research suggests that making your state harsh or cruel or rights restrictive to protection seekers does not significantly affect the numbers of people who try and seek entry. What it does do is instrumentalize and dehumanize and separate families and entrench racial and other forms of discrimination. And they also have an effect on our, whatever that is, political community in a way that I think is profoundly concerning and explains a lot of what happened in Parliament yesterday. So from that perspective, both the UK and the EU have failed in their reforms post-Brexit. They failed because they're doubling down on attempts to externalise protection. So following the UK's failed Rwanda plan, and to quote the great Steve Pearce, the flaws of the Rwanda plan were visible from space, but it does seem like the European Union is the one actor that's failed to see both the cost, the legal challenges, and the practical obstacles, because proposals are now on the table being debated that look to emulate third country style processing arrangements. Criminalisation is also an issue in terms of protection seeking, both in the UK and the EU. Here, I think the UK is a particular outlier in terms of the severity and the way that we treat irregular arrivals, in terms of potential sentences, for example, and the impact on individuals' lives. And then the third thing is selectivity. The idea that certain groups of refugees are invited, they're welcome, they come from Ukraine, for example, or from other states, whilst other groups of protection seekers from Syria, from Sudan, or from Palestine, they're not invited. In fact, everything is done to prevent those individuals from secure safety. And so this move to selective routes, to the invited refugee over the spontaneous arrival, is something you can see happening at both the UK and the European levels. So I'm going to conclude, because we wanted to end the chapter on some kind of hopeful note, not a helpful one, by returning to a brilliant article that another Cathryn D'Auvergne, wrote about sovereignty myths and the rule of law. And it's an article that's must be nearly 20 years old now, in which she talked about the effects of globalization. And she says that as states have less control over their culture, over their markets, over the policies that give identity to their political communities, so the salience of controlling migration increases. It's the one thing they can do, the last bastion, she says, of sovereignty. And in response, she identifies what she calls the protein potential of the rule of law to support rights and dignity-based decision-making and legal challenges. Now, in AAA, which is the UK Supreme Court judgment that stopped the Rwanda plan, the Supreme Court had a really interesting sentence, which I put on the slide in front of you. It says, a core principle of international law to which the United Kingdom government has repeatedly committed itself on the international stage, non-refoulement, is consistent with this country's reputation for developing and upholding the rule of law. So the prohibition on refoulement and the protection of the rule of law were linked inherently in the judgment. And I think that substantiates Cathryn D'Auvergne's arguments, and I think it provides a legal basis for challenging some of the policies at both the UK and the EU level that we are seeing at the moment. Thank you very much. Tour of misery. And I'll get over to Dr. Cathryn Costello, Cambridge, to talk about migration policies. Very much.
Fiona, yes. Oh, sorry. No, don't worry. Fiona, yes. Thank you very much. Hi, everyone. Thank you very much for the opportunity to come and speak today. I'm going to share our chapter from the book that's been mentioned, which is around citizens' rights, EU citizens' rights in the UK, both pre and post-Brexit. Our chapter begins with a kind of sliding door scenario of an individual we've called Maria for the purposes of our chapter. So in the first instance, the first scenario, Maria has moved to the UK pre-Brexit using her EU free movement rights. We go through her journey in the UK and what has happened since. In our example, she has lived in the UK for over 20 years. She has become a permanent resident here. She has married and met another Portuguese citizen since she moved to the UK, and she's had her children here. Her child's grandparents, the grandmother now also lives in the UK, and her husband's siblings have moved to the UK. So a multi-generational European family, and their life is now permanently here in the UK. Maria is based on a real person that we interviewed for the purposes of our 2024 book, which you can see possibly on the screens at the moment, which is called Low Paid EU Migrant Workers, which examines the everyday lived experiences of low-paid EU migrant workers who move to the east of England to work particularly in poultry factories in the region. In our second sliding door scenario, we set out what would happen to Maria if she were to move to the UK now, in our post-Brexit world, what UK immigration routes might be available to her and the associated costs of these various routes, including, for example, the minimum income threshold and the NHS surcharge. We conclude that as a cost-benefit analysis for someone whose motivation to move to the UK is for work, and particularly where that work is low paid, it's unlikely that Maria would move to the UK now post-Brexit. A, there are very limited routes that she could access, and B, it's very expensive. So she would instead likely seek similar work opportunities in another EU member state where she could still exercise her free movement rights. We open the chapter with this case study to fully illustrate the rights that were enjoyed by EU citizens moving to the UK before Brexit and the situation post-Brexit. As I said, our chapter focuses solely on EU citizens in the UK. We don't talk about UK citizens in the EU, of which other people have covered, and we footnote in the chapter. Over the next 3 slides, I will look through these 3 time periods: pre-Brexit, then negotiating and implementing Brexit arrangements, and then post-Brexit ongoing issues for EU citizens in the UK. So apologies in advance for how many times I'm about to say Brexit over the next 15 minutes. Yeah. A trigger warning. So, as I said, our focus is on rights associated with EU citizenship and in particular EU free movement rights. As you can see, possibly not very well on the screen here, this is a map from Eurostat, and it shows the percentage total population of intra-EU migration to member states. And the darker colours, the dark purples and the dark blues, are member states which have had over 10% of their now total population are EU citizens. Although the UK, it is a 2020 slide, so the UK isn't covered here. We know that we can confidently say from the EU settlement scheme statistics, there have been over 6 million EU citizens who've applied under the EU settlement scheme to retain their rights to live in the UK. So we can say that the UK would also be at least a 10% plus, so a darker blue colour here as well on the screen. And in fact, where we did our research for the book in Great Yarmouth, which is on the northern coast in the east of England, in the more central wards, about 1 in 4 people were EU citizens. So we can say that it's clear we've had very high levels of EU migration, perhaps some of the highest. And I'll come back to these numbers when I talk a little bit more about some of the post-Brexit operation of the EU settlement scheme. As well as the rights and entitlements associated with free movement, our chapter also outlines some of the limitations and qualifications which exist in the context of EU free movement rights. The most protected group of free movers are those who are in work in their new host member state. Those who are not in work face qualifications in accessing, for example, welfare benefits and housing assistance. And in the chapter, we draw out some of the case law of the Court of Justice of the European Union, which has dealt with the tension between economically inactive EU citizens, their free movement rights, and their rights to access welfare benefits in the host state. To summarise it very briefly, the main takeaway is that the court has taken an increasingly restrictive approach to economically inactive EU citizens accessing public funds, instead upholding member states' rights to protect public finances by setting out that such citizens should not become a burden on the member state to which they have moved. One of the key drivers of this protectionist stance is the idea of welfare tourism, something that has preoccupied member states, including the United Kingdom. And in the chapter, we take as an example a speech from David Cameron in 2014, setting out the steps he was taking to make access to welfare benefits tougher for EU migrants in the UK, something I think we may return to in the questions, as it's also come up in the news again today. However, other research shows, and our own research supports the fact that the welfare tourism is not one of the major drivers of EU free movement. In fact, as I've just said, EU law and the way the UK implemented EU law did not really allow for this to happen anyway. Conversely, our research shows that those in more precarious work or more precarious housing situations who'd moved here pre-Brexit struggle to prove their entitlements to benefits, even when they were in work, due to not being given the correct paperwork to prove their rights, or the fact that their 0-hour work did not meet minimum income requirements to claim welfare benefits. And I'll come back to this point regarding accessing welfare benefits when we talk about the situation for EU citizens with pre-settled status in the UK post-Brexit in a moment, when we look at whether or not anything has changed now for this group. So moving from 2014 into 2016, as you will know, after the referendum result, a period of negotiation took place between the UK and the EU, culminating in 2 main international agreements, the Withdrawal Agreement and the Trade and Cooperation Agreement. I will speak only about the Withdrawal Agreement, particularly Part 2 of this agreement, which guarantees the rights of EU citizens who were living in the UK pre-January 2021. To implement the rights set out in the withdrawal agreement, I'll just briefly cover the UK introduced via the UK Home Office, the EU settlement scheme. This was an application process for EU citizens and their family members already in the UK. It introduced two statuses. So firstly, settled status, that was for EU citizens who had already lived in the UK for more than 5 years, were able to prove this. They were given settled status, which is equivalent to indefinite leave to remain. And those who'd lived here less than 5 years were given something called pre-settled status, which is limited leave to remain. And this group need to make a further application to the scheme in order to upgrade to settled status. To date, there have been over 8.5 million applications to the EU settlement scheme, which the Home Office say equates to about 6 million people, or probably 6.5 million people. From this group, about 50%, so the blue half of the circle there, have received settled status. They have indefinite leave to remain. And about 34%, which equates to about 3 million people, have received EU pre-settled status. And this is the group that will need to make a further application to the scheme once they pass the 5-year mark in order to upgrade to settled status. And then we have other outcomes here, including 9% of applications which have been refused to the scheme. The EU settlement scheme was a digital-first scheme in both application and in status granted. In fact, it's been a flagship programme for the Home Office, which is moving in an increasingly digital direction, as the recent introduction of e-visas also highlights. The digital-first approach, however, has been problematic for EU citizens without the appropriate evidence of, or the appropriate digital footprint to prove their residency in the UK. Those who have limited digital skills, obviously, and those who also have limited English language skills, and for whom a large group of those we were working with in Great Yarmouth and Norfolk would have fallen into very limited English language skills and digital skills, as well as lack of documents. But issues not just for those who needed to make an application, but also for those charged with checking status. So landlords and others who equally may not have the digital skills required to undertake immigration right to rent checks, of which we found examples in our research in Great Yarmouth of landlords who were really struggling to undertake the new digital immigration requirements and responsibilities that they now needed to do. Despite the success of the scheme for many, and I think 6 million applications is a huge amount of applications to have been able to grant status to, there is a small but still significant number of EU citizens who are struggling with their application or their status management, or in fact have not applied at all. And it's to some of these issues I will turn to now. So despite the distance from the deadline from the EUSS, so the deadline to make an in-time application was the 30th of June 2021, so we're over 4 years past that point now, we are still seeing a number of late applications to the scheme. And I don't know if you can see on the screens here, so the bottom half, the 1.1 million here is repeat applications. So of that, 3 million people have EU pre-settled status, 1 million have already made a repeat application to upgrade to settled status. And the orange segment is late applications. So there have been over 700,000 late applications to the EU settlement scheme. And this shows the importance of having the availability of the late application route. When the deadline was first introduced, there was a lot of questions about what would happen to those who didn't make an application in time. Would they lose their residency rights overnight? Would there be a cliff edge for which a kind of repeat of Windrush in a sense? But actually what happened was the availability of the late application route, and we can see just through these numbers already how important that has been for a significant number of people who have needed to make an application. And then the other segment, the yellow segment, is almost 600,000 people who have applied as joining family members of EU citizens. The next kind of set of issues is around the pre-settled status, the limited leave to remain that people are being granted, and the rights that are attached to it. So coming back to the issue of accessing welfare benefits and housing assistance, etc., for pre-settled status holders, these rights are still conditional and qualified pretty much in the same way that they were pre-Brexit, although recent case law has recognised the role of the Charter of Fundamental Rights and the importance given to an individual's right to live in dignified conditions. Two other issues which have come to light over the last couple of years regarding pre-settled status are firstly around the potential expiration of the status, which I'll explain, and secondly around issues with absences and continuous residency requirements. So firstly, the expiration of status. The IMA, the Independent Monitoring Authority, an independent body set up under the withdrawal agreement to monitor the application of citizens' rights in the UK, they brought a JR related to the potential expiration of pre-settled status and what this would mean for individuals whose status expired. In this instance, the court ruled that the withdrawal agreement offered lifelong protection, and once these rights were granted, they could not be taken away due to a failure to apply for further rights after a 5-year period. So the UK government, in implementing this ruling, introduced an extension for pre-settled status holders, firstly for 2 years, which they then extended to 5 years, presumably intending that within this extension window, an individual would make the upgrade application to settled status. The extension is, in some ways, a can kicked down the road, as what is not clear is what happens to an individual who doesn't make the upgrade application within their additional 5-year window. And for those who are more vulnerable, not digitally literate, in atypical work, without proper paperwork, no English language skills, etc., etc., actually, this is entirely possible that somebody could once again fail to make that application. Moving on to the issue around absences. So while the EUSS is a lifelong status, there are instances in which it can be lost. For example, after lengthy absences from the UK. So this is more than 5 years if you're a settled status holder and more than 2 years if you're a pre-settled status holder. An unintended knock-on effect of the extension in the context of absences was that our research showed some people at the time mistakenly believed that the extended status meant the Home Office had disregarded any previous absences, and the clock on their pre-settled status had started again in effect. So they believed it had spent a second chance to restart the clock and their countdown to being able to access settled status, irrespective of any absences they had. The Home Office also recognised this confusion, and in this year, in July 2025, they amended the rules around absences to address this issue. So the new absence rules say that if pre-settled status holders can prove they have been in the UK for the last 30 of the last 60 months, they will have completed a 5-year continuous qualifying period to apply for settled status. And that's important that they're able to do that, because you need to prove continuous residency in order to be able to upgrade. So actually the rules around absences become really important for those who want to be able to attain indefinite leave to remain. And finally, the point about British citizenship. Our research shows that many EU citizens in the UK, British citizenship is seen as the gold standard of security for life, with many reporting that they plan to make an application, fearing that they could lose rights or changes could be introduced under the EU settlement scheme. Particularly as the government talks about introducing delays for other groups to access British citizenship, it's interesting that those, even with robustly protected rights under the withdrawal agreement, fear that settled status is not enough and the best protection would be an application for citizenship. However, making an application is subject to language tests, like the UK test, and other costs that, particularly for many of those we've been researching in Great Yarmouth, could make the application out of reach. Nevertheless, almost all the parents we spoke to in our research said they plan to apply for British citizenship for their children. So we expect to see many multi-citizenship planning in the UK in the future. So to conclude, Brexit is not yet done. And as we've said, some individuals are still in fact making a first-time application for the EU settlement scheme to claim their rights, and maybe many more, up to perhaps 2 million or more, will need to make a second application to upgrade their pre-settled status to settled status. The reality is that the EU now hosts the largest European Union citizen diaspora in the world, and many of this group, either themselves or their children, will become British citizens. So this means that a good relationship between the UK and the EU remains as important as ever. So thank you very much, everyone.
In a deviation from the rule that everyone on the panel has to either be called Cathryn. Steve. Yes, sorry.
I'll just press forward. Well, thank you very much. Thanks for the invitation to speak about this. So I'm looking at British migration policy after Brexit, obviously essentially excluding the issues we've looked at already, the asylum issue and the treatment of EU citizens who were here before Brexit. As we'll see, British migration policy post-Brexit does actually include EU citizens who arrived after that. They're of course not covered by the protections, or essentially not covered by the protections in the withdrawal agreement. So, too far ahead. So, there we go. So I'm looking first of all at how much divergence there was between the EU and the UK prior to Brexit, then at what has happened in the EU post-Brexit, then at what has happened in the UK post-Brexit, or obviously rather more on that, and then at the specific issue of relations between the two post-Brexit. It looked for a while as if there wouldn't be such a thing on migration issues, unlike trade and home affairs cooperation, or criminal law cooperation. But of course, now there is starting to be some more of it. So I'll say a little bit about that as well. So, pre-Brexit divergence. Now, as you've heard, but this is even more strongly true in the area of legal migration outside asylum. The UK had an opt-out. So despite that impression that many people were given during the referendum that all immigration into the UK was somehow a feature controlled by the EU, that wasn't the case. Obviously, the EU nationals' immigration was part of free movement law. Parts of the asylum movement to the UK were affected by EU asylum law, which we had opted into. We opted into the first phase, only a bit of the second, of asylum law. But even there, it didn't mean everyone could come into the country who was coming in from Syria to Greece or Italy could automatically come to the UK. That was a false impression that was given. But everything else, the visas, the border control, the legal migration law, and most of the law on illegal or irregular migration that the EU had adopted, the UK had opted out of. Some of that, the visas and border stuff, was related to Schengen. Of course, we were never going to opt into that because it would mean we'd have to abolish internal border checks with the European Union, which we always maintained and always had the possibility, was to reject non-EU citizens at the border because we had those checks, which had been abolished in principle between many EU countries. So we were never likely to opt into that, despite the impression given sometimes that we didn't have such checks. Obviously, as you'll know, if you cross the borders back into the UK, we do, and always did. So we didn't want to opt into that, and then we didn't want to opt into the stuff that the EU had done on legal migration. And the second from the bottom there is a summary of that. There is EU law on family reunion for non-EU citizens, on non-EU students and researchers, in fact, and on aspects of labour migration law. The EU has nibbled a few bits and pieces of labour migration law, just as it nibbles a few bits and pieces of employment law, very similar sorts of areas of law. This is where the EU has, because of differences in national labour markets and so on, done some interesting degrees of harmonisation, but not fully aimed to fully harmonise it. And particularly the biggest part of the EU's control of irregular migration is something called the Returns Directive, which is a fairly comprehensive, much litigated law on detaining irregular migrants and expelling them. And the UK opted out of that. Well, so now post-Brexit, what has the EU done? And this again is a brief summary. I want to say more about the UK side, but as a comparison, and one thing about this subject, because of the opt-outs, is that it's unlike asylum and unlike a lot of the other issues in the book, in that the UK had so little to do with it that making a comparison with what's happened after and the reasons, thinking about how things have changed because of Brexit, isn't so much about the UK no longer being bound by the law, right? Yes, the Rwanda policy happened because we were no longer bound by EU asylum law rules that at the time, until soon, would have prevented it. That's because we'd opted into that. But everything else that happens with non-EU migration, we had never opted into it. So it was never a legal issue. We were never being unbound or suddenly free to act, legally speaking, on non-EU migration. What is probably more accurate to say is that economically, the sheer number of EU nationals that came to the UK meant that a lot of spots on the labour market and a lot of international students coming to universities and so on were EU citizens. So the UK felt constrained politically and economically in terms of having a more liberal policy towards non-EU citizens. Never a legal constraint, though. Some people talk as if there was. It never was a legal constraint. There was a choice that was made, I think, because of the sheer numbers that were coming in already from especially post-enlargement of the EU, who were EU citizens. But I'll come back to that when we look at what the UK has done. But this is what the EU has done post-Brexit. It's amended its visa laws, changed its visa list. It has it's amended its law on a visa information system, collecting data on visa applicants. It's amended its border code in several ways, partly to make it easier to not let people in at the external borders, or to return them quickly across the internal borders, or to bring in internal border checks back more than they were before. It has amended its legal migration law, partly to deal with highly skilled workers in more detail. That's what it calls a blue card law, partly to change its law on the single permit to those are a broader group of migrant workers to avoid exploitation. They're less attracted to jobs with the same employer than they used to be under that law. It wants to replace that returns directive that by a regulation which is much more restrictive than that directive has turned out to be. The EU court has got to it and made it more liberal than I think they were expecting when they adopted it. So the idea is to make it more restrictive. And you've heard about the overhaul of EU asylum policy already. Now, on the UK side, well, what have we been doing? Well, I've broken it down by topic. One thing that Cathryn said a little bit about already is that we have special schemes, or some of them are ended or half-ended, for Ukraine, Afghanistan, and Hong Kong. Now, you could see them all as de facto asylum schemes. And sometimes when the government wanted to say we have safe routes, to some people, it would describe them. Both the last and the current government sometimes describe these as asylum schemes, but technically speaking, they are immigration schemes. Unlike the EU's temporary protection for Ukrainians, we obviously left the EU. We didn't do that at the time of the invasion. We did a series of other things instead to help Ukraine. So in the end, we helped about 200,000. But so it wasn't minor, but nevertheless, it wasn't. We did that quite differently from what we would have done had we still been in the EU. Family reunion is an issue on which the UK has always been more restrictive than the EU. It's the one thing that the UK didn't liberalise as a de facto consequence of Brexit. It's liberalised the law very slightly around the Brexit due date, only because of a Supreme Court judgment requiring it to be a little bit more flexible about minimum incomes for family members. And ultimately, by 2023, which is the point where the post-Brexit UK policy starts to take a very restricted U-turn, family reunion was part of that. The income threshold for people coming in as family members jumps up from, I think it's 18K to 29K. It might go up further. And two groups of people, most postgraduate students plus care workers, especially, both of whom were bringing in significant numbers of family members, were banned entirely, regardless of income, from bringing in family members. So that is part of the very significant fall in migration numbers to the UK over the last year, which isn't perhaps fully appreciated that it's happened, but it very clearly has in the hundreds of thousands, that fall. Now, in addition to that, what else has changed? Well, students originally were part of this great liberalisation. The law on admission of students was liberalised, simplified in many ways in 2020 at the Brexit dates, of course. And then that's when the graduate visa scheme was introduced to allow graduates to stay for up to 2 years. The current government's now cut that back to 18 months, not quite abolished it, still more liberal than EU law. Their version of the graduate scheme, although it's a minimum standard, it's still more generous in the UK. And EU law doesn't deal with students' family members. It's up to each member state. So we can't fully compare the UK and the EU because the EU hasn't harmonised all of the laws of each member state. You'd have to do a very complicated comparison on some of these issues to look at each member state's national law. But what we can say is that the UK, other than on family reunion, students, and in a moment we'll see on labour migration, became significantly more liberal towards non-EU citizens as of Brexit Day, and then did that screeching U-turn in the last 2 years, starting in 2023. So for students, that was partly about the change of family members, partly about the reduction in the graduate visa, and also partly about a levy, which I think the Chancellor will impose next week on international student fees. Right, so labour migration. I've made that small, haven't I? But the paper goes through some micro detail, but just in general terms, there's been a series of different types of liberalisation in the run-up to, and especially in 2020. For instance, nurses used to be subject to a cap on skilled workers. They were taken out. It was already foreseen, even in the run-up to Brexit Day, that, well, if EU people aren't going to be coming in the same numbers, they won't have free movement anymore. We have to ensure there is a workforce for the NHS, and therefore the caps on skilled workers no longer applied to doctors and nurses, for instance. And after 1 or 2 summers, it became clear that the people who said, Brits are going to go out and pick fruit and vegetables to replace all the foreigners, weren't themselves volunteering to go out and pick fruit and vegetables. Nobody was. And so, the government introduced and expanded and retained a seasonal workers scheme to make sure that that important industry actually survived. Because, obviously there's people, somebody needs to be doing that work. Now, there were some restrictions retained, but the bottom left is the crucial point here. That big liberalisation in 2020, the wage threshold then drops to £25,000. So about what was the average wage then, or just perhaps even slightly under. It was even lower for some key industries, shortage occupations. And there was a special scheme introduced for care workers, on the basis of which many people came to the UK for several years. They redefined skilled worker more broadly so it wasn't just university graduates, but people who'd finished secondary school in effect, and a series of usual features of labour migration, like having a cap that disappeared on numbers entirely, and having to do a labour market test. Can a British person do this job? That dropped as well. So, and that was all very explicitly designed to compensate the British economy for the assumed, and as it turned out correctly assumed, drop in migrant workers coming from the European Union. So that change was consciously, not a legal change, as I said, because we could have done this at any time for non-EU workers. But for non-EU workers, that change was really designed to fill the assumed gap problems with the labour market, the good result from shortages, really, of having left the European Union. And there were other micro-liberalisations for a couple more years. But of course, then we get to the U-turn. I've already mentioned the restrictions we get after 2023 on students and family reunion. But from 2023-24, the wage threshold goes up, £38,000, so well above the average wage. It's still a bit lower for some occupations. That care worker visa, there were lots of restrictions then brought in addition to family members no longer being able to come, and both the numbers of family members and the numbers of care workers, as well as they can't bring their family, and because the eligibility is restricted, the process of recruitment is now restricted. Those numbers have dropped as well, and the current government effectively wants to phase that out, the care worker scheme, even in its limited form. And the definition of skilled worker, having been broadened in 2020, is rolled back. It's to a higher level of skill as it was before 2020. Now, having said that, in addition to that sort of return to the previous system, and in many ways a more restrictive set of rules for non-EU citizens than the previous system. Now, of course, you could say even more restrictive because it's applied to new incoming EU citizens as well, which it never was before 2020. The EU and the UK, not having had relations on this issue for a number of years, have started to have relations on this issue, at least in limited areas. So, first of all, there's the prospect of a youth mobility scheme. which the EU suggested to the UK in 2024. The UK said no, although it had previously contacted some member states. It didn't want a deal with all of them. So there was a kind of push back and forth for a year. Eventually, as part of this big reset deal in May of this year, the UK agreed to negotiate a youth mobility deal in principle. However, that doesn't mean there is a deal yet. Most of the other stuff in that reset hasn't happened yet either. It's just at some level of negotiation. And with the youth mobility deal, if you go back and look at the text they agreed, it is quite vague. Even on some basic things, it's not even agreed whether it should be a treaty or not. The UK wants a memorandum of understanding. That's what our youth mobility schemes always are with various other countries. The EU has never done this before, a youth mobility thing, but it wants a treaty. They would be legally binding, and there presumably be arbitrators involved and so on. So apparently they cannot even agree on that. Plus, there's a series of details that, like exactly how a cap might apply on the numbers. They kind of agreed there would be a cap, but I don't think they've agreed how. So that's an issue. Whether tuition fees should be equalised. Of course, that would remove the some of the higher tuition fees which the universities use as income from EU citizens. They'd be having to charge home fees. Even though home fees are going up a little bit with inflation, there's still a big gap there, and that might still in effect be a cross subsidy to loss-making home fees students for many departments, which universities can't easily afford to do. So that may be a big issue, and NHS surcharge might also be an issue. There might be a few others in there as well, but it doesn't seem that that will be easily done, as attractive as many people find the idea. I think the government also is worried about the numbers of people who might use it, inflating the net migration numbers in the run-up to an election. That worries them as well. So in addition to that, you heard a bit already about the UK-France migration deal. Although that's with a member state, there is an EU law angle to it. France had to consult the EU Commission and other member states on it. The press suggested some other member states didn't like it, but ultimately the EU Commission approved it. We don't have the benefit of their legal analysis. They didn't publish it. All we have is a tweet from the Commissioner saying, yeah, this is great, crack down on illegal immigration. And they didn't pass legislation to approve it, which they sometimes do with bilateral deals like this. So, but they didn't. So whatever interesting EU legal arguments might be made, and I think some people are challenging this in France, in the courts there. There wasn't a legal barrier at the time. Now, one interesting thing about it that's directly linked to EU law is that it expires on the 11th of June, and that seems like a random date. It is, in fact, the day before the EU's new Asylum Pact will start operating. So perhaps the assumption is here, well, you'll have to rethink it or perhaps end it in light of the EU Asylum Pact. I mean, I presume the UK and France will have discussions before then to see what happens subsequently, and there may be some additional legal arguments that could be made because the Asylum Pact contains more details where there may be a conflict, there may be a external relations law of the EU issue there. Now, as you heard, in principle, it's one in, one out. In practice, there was some talk of 50 people a week being moved. The last thing I saw was about 100 had been moved, about 94 in the first 2 months or so of operation of the deal. So obviously less than 50 a week. Presumably about 100 have come back. We haven't heard much about that. About 100 that we've accepted from France who want to come here. We do know that 2 people that we've sent have come back, who obviously weren't meant to. We can see that they have not been deterred. This isn't unusual in expulsion, that people who are expelled return a few years later again and again in some cases. I don't know if they get counted more than once in the statistics if they do that or not. And then finally, we don't know much about it, about as much as these macaques, but there is an EU-UK deal over Gibraltar announced in July, but we don't have more than a press release on the details. I think there'll be all sorts of interesting things there. I suspect they didn't even have agreed all the details at the time they announced it. But at some point, we will see the text of that. And it's not only about immigration, of course. it's an interesting issue there about free movement and customs and taxes. But there will be something in there about some kind of quasi relationship between Gibraltar and Schengen, and that's probably going to mean, it already seems to mean in practice, that Gibraltar is not letting many Brits settle there because, or newly settle there because of the way in which that process would work. But it'll be interesting to see exactly how that might work. So in general, well, what's happened? Well, we had a liberal UK policy as a de facto consequence, really an economic or political consequence, not a legal consequence of Brexit as far as non-EU migration was concerned. Of course, balancing out the drop in EU migration that was in fact bound to happen as a result of the consequence of Brexit. So you could say EU law was originally going in the same broadly liberal direction. You can't really overstate that because it is only partial harmonisation. It leaves some things out or some minimum standards. So there's still some scope for member states to be more or less liberal. I see today, though, there was a deal in the EU on some new legislation on a talent pool of non-EU migrants, even though that's optional and these member states in control of the numbers they admit and so on. Certainly sounds very different from the mood music we get from the UK, right? No one's talking about a continent of strangers and so on, or quoting whatever Powell quotes they might be able to find, where even the discussion about limiting migration and controlling it falls short, at least at the official levels, of the rhetoric that we have from the current government, never mind previous government. And of course, we have had this UK U-turn, and it hasn't, in fact, been paralleled by the EU as such. It might, of course, be paralleled by individual member states. You could drill down into the Dutch government whacking down on international students, for instance. But on the other hand, you can see Italy increasing the number of labour migrants. So that great deal of flexibility from member states that's still left because of that partial harmonisation is used in different ways. So it's hard to compare the labour migration policies because of that very nature of how the EU works. And of course, it's a different type of comparison about how Brexit has worked because we weren't bound by most of it anyway. Right, I hope that's useful. I don't think it's
So you've heard a lot about movement of citizens, of migrants and protection seekers. Now is the time for questions and conversations. So I'm going to take 3 at a time. If you could just introduce yourselves, that would be helpful. And if there's a particular person you want to answer, please do say that as well. Thank you. Yes.
Hi, Pavlos Eleftheriadis, fellow of Mansfield College and a colleague of some speakers. So I wanted to be asylum question because it seems to me the most politically salient. And clearly the British government wants to amend certain provisions that are internationally entrenched. So there are 2 levels here. One is the International Refugees Conventions, and the other one, the European Convention of Human Rights, Article 3. How, if there is this conflict, I know it's an unfair question, but if there is this political conflict between what the majority political parties want to do and what the international conventions require, okay, UK and other European countries, what is to say that the international structures will collapse? I mean, we think it's unthinkable that Britain will say, we're out of this convention, we're out of the ECHR. But is it true? I mean, we as lawyers, we assume this is part of the furniture, it's part of the background. Use Coggins, perhaps somebody would say, but the political reality now is so surprising. I find it, I find it shocking that we're having even this conversation with this government. But what is to say that these international structures will not collapse in the next 10 years? I know it's an unfair question to predict the future, but we've grown up thinking these are parts of the structure of European law and international law. Yet, are they so solid? What you make any? I know it's an unfair question, but if you could make any speculative comments, I'd be very grateful.
Right at the back, yes, shout.
Hi, my name is Jackson. I'm a public policy master's student here at Oxford, and my question has to do with the Syrian asylum situation. So in the Home Office's new asylum plan, they acknowledge their efforts in encouraging voluntary repatriation Syrian asylum seekers, as well as exploring forced repatriation of asylum seekers. And given the Home Office's previous policy note in July, sort of arguing that the situation in Syria does not meet the requirements for the UK to grant humanitarian protections, what recourse do either asylum seekers themselves or civil society have to challenge the Home Office's assertions and sort of prevent what seems to be the inevitable march towards forced repatriation?
Thank you all very much. Really interesting and wonderful conversation. It's nice to see the visitors to Oxford. So my name is Fiona. I'm the professor in EU law, fellow at Somerville College, and director of the Institute of European and Comparative Law. So my question is both about Brexit and about the new pact on migration and asylum. So in relation to Brexit, I'd like to ask you about a particular group which won't surprise you, the Zambrano parents. So I wonder if you could perhaps give an update on what has happened to those families. I had read at some point that the applied for status, and then when they were able to apply, they were mainly refused status. So I don't have information on that. And in relation, perhaps, Steve, the new pact on migration and asylum, do you think it's compatible with the European Convention on Human Rights? Thank you.
Do you want a minute? And I'll just a minute if that's okay.
Okay, so Jackson on Syria. So I have been doing a different piece of work with Cathryn Costello and Fiona, looking at cessation practices across the Council of Europe, so EU and non-EU. And of course, the attempts to return people involuntarily to Syria was at the heart of that piece of research. The only country that we found that is returning to Syria is Austria. There was interim measures ordered by the European Court of Human Rights. They were lifted. One person has returned. They were forcibly disappeared when they arrived in Damascus. Various UN working groups on enforced disappearances are looking into that. In terms of then the UK position in relation to Syria and for your announcements, no one is going to be returned to Syria from the UK forcibly anytime soon. In terms of how cessation of refugee protection works, the standards you have to meet to show that protection has come to an end are higher than the standards you have to meet in order to get refugee protection. So there's a built-in steer towards people retaining status and then naturalizing in the host state. But it's a really interesting question, because what the UK is doing is echoing a move across the European Union, which scholars like Jessica Schultz and others have talked about being the turn to temporariness. And again, this is outside of the common European asylum system, but it's a move to protection statuses that require regular renewal with kind of active processes of governance, subjecting individuals to renew, making it harder for individuals to naturalize. We saw that announcement yesterday. And in general, kind of keeping people at arm's length from the political community. So I think the issue here is not around people being returned to Syria, because that's still very much not the norm. The problem is people being held in precarious and statuses which often lead to destitution and attendance rights violations and kind of issues around human dignity. Just the ability to plan for your life being taken away from huge swathes of people. And on the amending provisions in relation to the Refugee Convention and collapse. Were you thinking of yesterday's announcements in particular? So again, this touches on some of the cessation issues and the routes to naturalization. And many of them are in direct conflict with the Refugee Convention. It's really hard to know that for sure at the moment, because one of the things is the paucity of detail in the announcement. If you read the statement, it's unclear what's going to be a change to the immigration rules. It's unclear what's going to require primary legislation. But I think what you're getting at is a kind of broader non-conflict set of issues between the UK and between European states in relation to the Refugee Convention, in relation to the European Convention on Human Rights. And I'm going to say miscogens, you got me there. So that's the idea that there are rules that have certain status in international law from which no deviation is permitted. I would say that non-refoulement has attained that status. I think the House of Lords were the Supreme Court were moving in that direction when they talked about non-refoulement being a norm of customary international law, when they emphasised the range of obligations the UK had, not just under the Refugee Convention or the European Court of Human Rights. But I think you're absolutely right that we shouldn't presume that the post-war international order that protects refugees is one that can sustain this level of deviation from it. I would say that there are hundreds of state parties to the convention, and it's a mistake to assume that something that happens here, it's obviously important for refugees here, but it doesn't necessarily reflect an international consensus. And so it's also the case that the Refugee Convention has immense salience in non-signatory states in relation to the Middle East, for example, and in other states where refugees are accorded protection and rights. Are you ready to take?
Do you want me to?
Yes, please.
Address Pavlos's question. So, in respect of the ECHR, I think we have been way too complacent for too long. And I think one of the things that I'm seeing a great deal of is serious attacks on ECHR. I get asked more often about chicken nuggets than I do, and this is actually a serious point. So for those of you not familiar what I mean by chicken nuggets, I do lots of interviews about this, and I'm almost invariably asked about chicken nuggets. It's a case about an Albanian who said he couldn't be deported because his son would only eat British chicken nuggets and not Albanian chicken nuggets. And unfortunately, at the first instance, this issue seemed to be persuasive to the judge. And in fact, of course, it was more complicated than that because the kid had learning disabilities, and therefore he was probably autistic. But nevertheless, it is a stick with which to beat the ECHR. And of course, when the case was appealed, the appeal is not reported, but the decision was sent back for reconsideration. Now, there is a really frightening move against the ECHR. I suspect I might be the only one in this room who might think there is actually something slightly positive about the statement from the Home Secretary yesterday. And the slightly positive thing in the statement from the Home Secretary yesterday is that she does not attack the ECHR. And in fact, if you read quite carefully what's said, she says we need to tighten up about some of the issues under Article 8. What's interesting is that when you're talking about deportation, in fact, the rules on deportation in the UK are very strict. And in fact, it looks like there's been some good work done here, but it looks like only about 2.5% of cases actually succeed when they get to the court in respect of Article 8 points, because it's got to be unduly harsh. So one, a ratcheting, it's quite difficult to see quite where the language goes from unduly harsh. Now, I mean, seriously, I mean, you can see, you can put as many adjectives in front. The thing that to me was most interesting of all, and the reason why I see a very small sliver of light in what she said yesterday, she did not touch Article 3. And for those of you who are not lawyers, the significance of not touching Article 3 is that Article 3 does not have an exception to it. Article 8 has an Article 8 exception. So Article 8 is the right to family life. Article 3 is on the protection against torture. And there is a clear statement that the UK government does not tolerate torture. And so there are some bits of slight positivity in there. And she says they're going to talk. Now, for those of us who are really worried about us leaving ECHR, which I think is a very realistic possibility if Labour lose the next election. And because Brexit shows that it can be done, that you can leave a multilateral institution, there is every chance that we will lose the ECHR. What I see here is an attempt, at least, to deal with some of the potential issues without caving in to those who are extreme fanatics to leave the ECHR.
I'm going to come to you on the pact, and you can return to the ECHR. Do you want to explain as well who unbound care is?
Yes, of course, yeah, thank you very much. So these are, unbound care is the primary care of a British national child. And we have included in our chapter a section on non-EU family members, rights holders and joining family members. I didn't talk about it here today. So as I said, the primary care of a British national child, they have, as you mentioned, really significantly high refusal rates under the EU settlement scheme. It's up to almost 80% of applications from this group, from this cohort have been refused. And in fact, there was some litigation, and the Home Office have updated their guidance to say if you already held another form of leave, then it's acceptable. These refusals are acceptable. So actually, unbound carers have been pushed down the Appendix FM route, which is more limited leave and much less rights than they would have been able to access under the settlement scheme. And recently, there has been the amendment put forward in the Border Security and Immigration Bill in April around who holds rights under the withdrawal agreement, who holds enforceable rights. For some time, the government's position was there was a true cohort of people who held rights under the withdrawal agreement, and then an extra cohort. And the extra cohort were those groups who were just simply in the UK pre-Brexit but weren't exercising their treaty rights. But the true cohort were those who were here but exercising their treaty rights. The amendment puts forward that everyone has enforceable rights under the withdrawal agreement rather than just the true cohort, as the government had previously put forward. The unbound carers are also excluded from that amendment. So we see another step where, again, they've been kind of marginalised from rights they could have otherwise access. So yeah, I think they're a particular group who have not fared well under the EU
And their children, because the point is that the children of the unbound care are British citizens, and that's why they were allowed to stay in the UK. So any indication of what then will happen with the children?
Exactly. You have a parent who, once that child turns 18, whose leave is therefore limited, and then I don't mean that's we kind of put that question in the chat as well. What happens then in terms of still a parent of a British child who right? His parents are risky. But yeah. Absolutely, yeah, for sure, and it's overwhelmingly impacting them.
What a small question, Steve.
You're already asked.
Well, first of all, on the ECHR, I mean, we're kind of assuming that it's just a UK issue, but I mean, the Prime Minister of Poland said he thinks maybe they have to leave the ECHR, and there's a group of member states that say they should change their migration interpretation. So it's not impossible. There could be an issue among certain member states to no longer be party to the ECHR. And in a way, that creates a legal mess, because in many ways, the EU legal system is much more entrenched and connected to the ECHR, is much more entrenched within it. It's referred to in the Charter, it's referred to in the Human Rights Clause, Article 6, and so on. So how do you take it out? How does a member state no longer be party to it? How does that work? That would raise some difficult questions, because it may end up being, if a group of member states leave, it becomes a dead letter. It becomes a kind of, as a French phrase, caduc, a null and void clause that exists but doesn't do anything. For 30 years, the EU treaty said that Algeria was still covered by EU law. It took 30 years for the French government to accept they weren't coming back and to actually amend the treaties to remove that reference. Maybe that's where the ECHR ends up. But certainly there would be people litigating about it in the meantime and raising those arguments in the meantime, and it would be a hugely messy affair for member states to leave it. I wouldn't underestimate the possibility of that happening either. On the pact, one interesting thing is that it has been challenged already from the other side. This is Le Pen's party in the French Parliament has challenged part of the pact to say it's invalid because it requires relocation of asylum seekers between member states. Now, I think that begs the question, because I don't think the pact does require relocation of asylum seekers between member states. But we'll see what the EU court says. And that case is, they don't rush these things. That case has been on the books for over a year, and no sign of them deciding it yet. So that will be the first challenge, I assume, to get decided from that side. Of course, the more obvious challenges from the human rights side. I don't think it will be a question of is the whole pact invalid. It will be a question of are some of the provisions invalid, such as the some of the removal of appeal rights, especially in Dublin cases, but perhaps also general asylum cases. It will also be an issue of the amendments, the 2 amendments that have been proposed to be adopted and then apply along with the pact, so become more restrictive even at the outset, as well as the proposal to change the returns law that I mentioned. I think the argument will be A, is that EU legislation itself valid? B, even if it might be, the issue will be how member states interpret it, because there's a whole series of clauses saying, well, yes, you can do horrible things, but you must respect non-refoulement. So what does that actually mean? Well, someone can still, at the end of the day, say, you must respect my non-refoulement. Even if I don't have an appeal right, you must, let me stay temporarily. Otherwise, there'd be refoulement. So, to what extent would member states' practices violate the core of either what the legislation says or what the EU court has said the Charter, or the future, I think, say the Charter requires. And then, of course, there'd be another issue of how much member states simply ignore the EU rules. And some of them have said they will already. And of course, Hungary already does. Hungary was fined 200 million euros over a year ago for breach of EU asylum law, plus 1 million a day. So that's another 500 million since for breach of EU asylum laws until it complies. There's no sign of it complying. It seems quite happy to get to 1 billion. And before we'll see what happens at the next election in Hungary next year. And of course, they've lost even more than that in rule of law reasons. So in Hungary, so if countries are willing to take the hit, as it seems that they are, or at least a financial hit, and if the EU doesn't seem to be willing to turn the screws any further on those countries, obviously it may make sense politically to wait for that election rather than turn the screws more. I think even if they are going to pick a fight with the member states, is it really going to be over asylum? More likely to be over them banning a Pride March and Hungary is prosecuting the person who organised it. That's the sort of issue or if Hungary ends up, cancelling elections, or there's some question about the fairness of them. I mean, that's the sort of issue that might get you into an escalation. I don't think it's going to be asylum. The Commission isn't that interested. Does try and enforce the law against Hungary, but it's not that interested otherwise in trying to enforce the law. With all sorts of pushbacks going on. The Commission has nothing much to do with them. It's fine with Poland stopping the right to asylum. It said nothing much about Greece doing the same. That type of level of enforcement that you would traditionally expect to see isn't happening because of the politics of the issue. And some key cases going to the European Court of Human Rights on pushbacks, what they decide, because the Human Rights Court is not always as liberal as people think. If they, take a liberal view, well, that sort of escalates the issue. But if they take this opportunity to pull back, as it were, on their traditional case law, well, is that going to be enough? That will be their kind of lock the court moment, like the US Supreme Court reacted to FDR before he replaced them or stamped the court. That would be the Human Rights Court's moment, I think, to say, here's our significant signal to member states, okay, we get the message where we're not going to be as aggressive on immigration rights. So, I mean, that is the possibility, the moment when the Human Rights Court could do that.
Is it worth just adding to that of course, a large number of member states now are disregarding the judgments of the court?
Yes, of course, yes. They're as I say, Hungary disregarding some EU court judgments, but not pushback judgments as well. Yes,
but
absolutely.
Germany, Belgium, I mean, they're significant. And so this issue about undermining the rule of law takes a number of forms, very overt in the case of Hungary, but it's not confined to Hungary.
I think to come back to the point on non-suspensive appeals and excise zones, I think there's a real problem with the EU legislature and states putting in place measures which appear to set up 15 EU reports at a national, regional, and at the ECHR level, because that plays into your question but the impact it has on the broader rights protection regime when courts are being used in a particular way. Obvious facts. I want to take another round of questions. I've got three very fast hands here, so 1, 2, 3.
Timothy Gartnash, European Studies Centre. Thank you for a very interesting panel. A lot to take in. 2 questions. First of all, on the Cathryn Briddick proposition, I quote, the harshness of asylum policies does not significantly determine the number of protection seekers in any particular country. Anyone who's looked at British media in the last few weeks has been told repeatedly that the harshness of Denmark's asylum policy did precisely that. And it is actually the case that the number of asylum seekers went down from close to 15,000 in 2014 to just over 2,000 in the last couple of years. So is that because there were other reasons for that decline? Or Denmark is the exception that proves the rule? Or the rule is not quite so universal as maybe you were suggesting? And if I may, I think Fiona, I just picked up when you said in your study in Yarmouth that people had said they wanted their children to be British citizens. If a significant proportion of your 34% actually proceed to settled status, that means, correct me if I'm wrong, that we have somewhere between 4 and 5 million people with settled status who would therefore be eligible to apply for British citizenship. Is that right? Well, 5 million pro-European British voters is a very significant electoral force. However, the Migration Observatory had a paper recently which pointed out that a really quite small proportion of them are actually applying for British citizenship. So can you say a bit more about why that might be and whether it might change if my dream were to come true?
Yeah. Did you have your hand up? Sorry, ask your hand. Yes, please.
Peter Chen, I'm an undergrad student at Brasenose. I have a question for Fiona and Cathryn. There's one sort of more preliminary question. You talked about this worry that people would lose their status if they don't apply to upgrade to settled status. The government announced a policy, as I'm sure you know, in January to automatically upgrade people. Is that persuasive to you? Do you see a problem for that system? And my second question is that I talk about there was a case from the Court of Justice about people living under pre-settled status has to live in dignified conditions. Anecdotally, I know European citizens who have been denied basic benefits such as housing and homelessness support on the basis that they're not allowed to access benefits. But anecdotally, that judgment doesn't seem to have been applied very fully. Do you have any research on this and how has it worked out in your experience?
I'm Sandra Leon. I'm a visiting fellow at the European Studies Centre. So I have 2 questions, one for the first speaker and the second one for the second speaker. So the first one is, you said that internal rules barely change the numbers of applications, of asylum applicants. So what are the most important drivers of applications? Is external conditions, international conflicts? Can you say a little bit more about the relationship between how internal versus external conditions shape asylum seekers, the number of asylum seekers? And the second question goes to the second speaker, and I was really intrigued about something that you said, that it's the perception about the stability of the rules by the people might actually make the system less effective. And what I mean is that you said that some EU settled citizens, they are not sure about the stability of those rules. And because they are not sure, they're actually thinking about moving towards or applying for citizenship, which makes the system less effective and less stable and actually more inefficient, because you are basically driving people to bear more costs and the administration as well to increase the cost. So I would like you to reflect more upon this, these conditions.
Good. Thank you very much for that. Should I get started? I think so. I'll take the citizenship question. So yeah, I think potentially there could be up to maybe 7 million people who eventually would have settled status. Who could, up to 7 million. I think between the 4 that are inhabited and the 3 that are settled. who might be able to then be on a route to British citizenship, potentially. But I think particularly for the groups we were interviewing, the issue around the cost is really massive, particularly if you're a family of four, maybe, who are making an application to British citizenship. It wouldn't be possible.
How much should it cost?
I think it's £30,000.
£2,000 plus
The NHS.
plus the citizenship test, plus the travel to get to the citizenship test. So you're talking probably about £1,500 for a family of four.
Yeah. It does keep increasing every time we seem to write it down. And then the English language requirement. So in the research we did in Norfolk, over 70% of our research participants didn't speak any English, despite an average length of 10 years already in the UK. And that was because English wasn't the spoken language on the factory floor. So most have picked up another European language, just not English, since they've moved to England. So that creates a massive barrier as well, I think. For their children, they might be able to apply for a concession for the fees to citizenship application. Oh yeah. So that's where for a lot of people the idea that citizenship for themselves may be out of reach, even though in an ideal world they would make an application, but certainly for their children they would be thinking about making that application. And we did speak to others, so Cathryn said about dual citizenship. So we spoke to someone from Lithuania, for example. For him, it would be a big decision because she would have to give up her Lithuanian passport should she make the application. And even though she lived in the UK for quite a long time, she said she very much felt Lithuanian and didn't want to. She planned to remain in the UK, but didn't want to be. So I think it becomes a very personal choice, but also a very practical choice sometimes for family members. But there are huge costs involved, which could affect each people. Yeah, so I think.
I say something about your question about pre-settled status. So, as Fiona explained, there are two statuses. Those that have done less than 5 years get pre-settled status, and then those who've done more than 5 years get settled status, which is equivalent to indefinite leave to remain. And if you have settled status, you get full access to UK benefits. If you only have pre-settled status, you do not, subject to the decision in CG, which said charter rights should be taken into account. But in reality, it's all very well to say charter rights should be taken into account, like the rights to child. But if you're a UK decision maker in Croydon, you've probably never heard of CG, let alone the charter. So it's probably not happening very much, as you rightly say. In terms of upgrading, yes, you're absolutely right. It used to be the case that you had to formally upgrade, which was very problematic because it was hard enough to get people to understand that they had to apply. As a result of the decision of the Divisional Court, they said it's a permanent status and you shouldn't have to apply. The problem, so for people in this room, they would have a very clear footprint because they will be paying taxes and so forth. And that's how the government was using the information they already had on people in order to automatically upgrade them. In fact, people in this room would have known how to apply anyway. The folk in Great Yarmouth who have very poor English, there's quite a large number of Roma Romanians, Roma Bulgarians who are illiterate in their own language. This whole process is a complete mystery. A lot of their work is undocumented and therefore they don't have the footprint. So therefore automatic upgrading doesn't work because the Home Office approach is dependent on having access to the digital imprint that all of us who are fortunate to be more regularly employed will have. Did we just say anything about Nigel Farage?
Yeah.
Because Nigel Farage is reflecting on these issues, or more than much reflecting on denying benefits to people. Now, what's interesting, if you listen to Nigel Farage this morning, is that he has now said that anyone with EU settled status will be denied benefits. And it's certainly true. If you look at the data, probably somewhere about 600,000 to 700,000 those with EU settled status are on benefits of some sort. And by benefits, he did clarify at lunchtime, it meant universal credit. But universal credit is a complicated benefit. And in fact, what it means is for a lot of people, again, the folk we've been working with in Great Yarmouth, it's that they're on very low pay and universal credit supplements their pay. If you also look at the data, you see that of all the migrant groups in the UK, those who have got EUSS, European Union Settlement Scheme, they are the ones who have the highest level of employment. If you put the data together, we can't say this for sure because we haven't done the footwork, but it does look like a large number of those who've got EUSS are doing low-paid work, still in chicken factories and farms, and therefore they get universal credit to supplement what their work. So they're working, but they're working for, and that's why they get universal credit. Now he wants to turn it off, and he sent his foot soldiers out at lunchtime to try and explain how this was done. Unfortunately, they had a mere passing understanding of the content of the withdrawal agreement. Because at one stage they talked about the fact you could do it by arbitration. Now, there is an arbitration provision in the withdrawal agreement, but it has nothing to do with sorting out how to amend the treaty. The arbitration provisions are where one side is accused of breaching the treaty. So, in fact, what really it means, they were thinking about doing it unilaterally, and if we do it unilaterally, that would be a breach of the withdrawal agreement, to which the EU would take us to arbitration, and we will lose because it is absolutely clear that we will be in breach of the withdrawal agreement. And it's serious because there is a bridging clause between the withdrawal agreement and the trade and cooperation agreement. Steve can probably tell me which provision it is, but there's a bridging provision that says that if you breach the withdrawal agreement, you also leads to a breach of the trade and cooperation agreement, the deal with which we trade with the EU. And that means that tariffs will be imposed, and indeed it could lead to the termination of the trade and cooperation agreement as well. His other fudged idea is to amend the withdrawal agreement. Now, as we know from the reset negotiations, which are being done by the hope to be done by the Labour government, this is not going swimmingly at the moment. And it's really difficult to negotiate with the EU because we are on the back foot. Now, the reform idea is that the EU wants to trade with us, therefore they will agree to amend the provisions about welfare benefits. Frankly, I think this is for the birds, because why on earth would the EU agree to amend a treaty which they negotiated in good faith 7 or 8 years ago now, for something which is entirely in the favour of the UK? We already know that there's concerns from the Romanian government, Bulgarian government and others that we are not complying with our obligations under the withdrawal agreement. The idea that we could just sever protection for low-paid workers who are Romanian, Bulgarian, I think is frankly false.
But presumably this narrative feeds into the precarity that people perceive in terms of their status and impacts on their life. Yeah, I think absolutely, yeah. And recently, a charity we did a lot of our research with when Reform was talking about abolishing ILR, that was when these discussions kind of resurfaced about the instability of the EUSS potentially as a status, like your question referred to as well. And again, these questions around citizenship and how people can remove themselves from this perhaps insecurity of this kind of moving, the idea that changes could be enacted overnight, even though those conversations weren't regarding EU citizens still felt the concern that actually could topple over for us next. So yeah, absolutely.
And just on your question, it's definitely not the Cathryn Briddick proposition. I wish my research went into these questions, but it doesn't. There is a wealth of empirical and other research on this. In the chapter, we cite Lamis Atolate, who's done comparative studies of different jurisdictions and the way that they have embedded so-called deterrence policies and the effect that has on numbers and arrivals. And there is a small correlation, but it's very small and statistically open to question. And she's written a broader book on these questions called Discrimination and Delegation to try and understand states' responses to refugees.
UK Home Office has its own research as well that points in this direction. The idea that people who are feeling war and conflict are sitting down with a spreadsheet of different sets of rights and obligations, that they understood the UK's partial and selective engagement with the common European asylum system and made decisions on that basis is frankly ridiculous. The research we have until when people are able to make decisions, which is seldom, indicates that language and family reunion are the two big factors. So people want to reunite with family members more than anything else, very obviously. And then if they have a language, that motivates, if they can, their decision to move. One of the things that is interesting is that post-Brexit, there is emerging research that suggests that because people have been refused in the common European asylum system, that has made the UK more attractive as a destination. And so smuggling and other facilitators of irregular migration are able to say that the UK can't check your fingerprints anymore. We can't ascertain if someone's had a refusal decision in another European country. So I think that is certainly an issue that isn't talked about. The fact that we don't have the Dublin system in place, and so the Rwanda agreement came out of that inability to return people to Europe, for which the deal is some kind of partial response to it, but as has been explained, it's very time limited and its utility is questionable. Interestingly, the cases I have looked at of people who have entered the UK-France agreement had family members, so correlating with the broader package of research. I mean, on Denmark, I have to say I don't know the answer to your question. I know that numbers across the board obviously dropped after 2015. I know from the research on temporariness and precarity that Denmark is one of the leading states in return to temporariness in terms of requiring refugees to reapply for status, having incredibly restrictive rules on family reunification. I wouldn't want to say that there's a correlation between that and the numbers that you have described, because I haven't looked into it. But Denmark does operate in a strange way in relation to the common European asylum system as well, doesn't it? Do you want to?
It's in Dublin.
Yes.
But then it's because it's opted out of everything else, the EU court says, well, not everything else fully functions in relation to Denmark. So if someone's been rejected by Denmark, they don't have to be rejected somewhere else necessarily as well, whereas otherwise you would have to follow the previous rejection in the EU for some purposes anyway. So it is quite a complicated rationale. I understand we escaped all that because you have to do everything going forward. But it was a bit complicated in not anymore. Denmark, it remains complicated. And also this issue of the numbers. I know, remember the numbers as a whole have dropped for the whole of Europe in the last year. And the EU is patting itself on the back, saying we deterred all these people, we're scaring them away with our pact. But of course, the biggest drop you can see is in Syrians post-Assad being removed. And you immediately get to what an unusual situation of the biggest number of asylum seekers not needing a visa. Now they're Venezuelans coming to Spain. So usually it's people who need a visa and have to break the law because of it. Venezuelans don't have to. Obviously, just fly without a visa. But that is the main reason Syrians dropping. Of course, it's still difficult to send them back, as you said. But the fact is that fewer of them want to leave.
Yeah, and so things like go and see visits, enabling people to retain their status, to build connections at home, that is the kind of thing that if the EU is sensible, European states are sensible, they would look to. But my final thing on Denmark is that the UK is moving allegedly to a 20-year period for refugees to settle. Denmark is 8. So a lot of things I've read about Denmark haven't correlated with the few things I do know about its asylum system. We have time for a couple more short questions before we end. I know Othman had his hand up, and I saw one in the middle here that then went down again. Did you want to go first?
Yes, Cathryn, thank you. Awesome. I'm Mr. Sykes from the European Studies Center. I've got one question because you mentioned the externalization of migration control. And what I would like to know is why the UK, Rwanda, and Italy, Albania, we know why, for legal reasons, they did fail completely. But the EU managed to get away legally with its agreement with Turkey or Libya. Obviously, there are the incentives and everything that we know, the money that they gave. But legally, how did they manage to get away with it?
One more question that was in the middle, and I didn't see whose hand it was.
Jack from the one of their education rights. So that's about one of the, well, it was more minor from in yesterday's announcements, but it's a constant stream. That's around the growing integration between modern slavery protections and the asylum and immigration system. I was wondering if the panel could speak on why that integration has happened over the last 2 or 3 years, at least in policy rhetoric, and also whether this is setting the UK up with a conflict with ECHR, because they never mention Article 4, interestingly, alongside Article 3 and Article 8, but it seems to be pertinent. It seems to be that the restrictions on modern slavery protection for people who are deemed to be gaming the system is going to bring the UK in conflict with ECHR. How they see that playing out.
Steve, did the EU get away with their Turkey deal?
Did they get away with the Turkey deal? Well, first of all, the EU court said it couldn't be challenged because it wasn't really a deal. That the EU did it. I mean, even though if there are conclusions of EU bodies, and part of it was about the accession negotiations and visa waivers, which only the EU could grant because it's EU legislation. Oh, it's not really an EU thing. So that was dubious. But then what's happened subsequently is that when Turkey started to refuse to take people back from Greece, Greece said, oh, they're all inadmissible. You had 10,000 people sitting in Greece in limbo because Turkey wouldn't take them back, and Greece refused to accept their asylum application, to consider their asylum application, because it said Turkey should take them back. Well, it's fairly clear in EU law that you can't treat someone as inadmissible if the other country won't take them back. But eventually, the Greek courts finally decided they had to ask the EU court about this. They'd always resisted asking him a question before about asylum. The EU court said, well, obviously, they can't be inadmissible. But at this point, these 10,000 people have probably wandered off to other member states and applied there. And the case law says if a member state is breaching human rights, you can go and apply somewhere else despite Dublin. So I think a lot of that was happening. A lot of people have actually got refugee status in Greece. Greece refuses them benefits, probably illegally. And they also moved despite Dublin to other member states. So I think that, yes, in a way, there was a kind of short-term victory in the sense only because it couldn't be challenged. So the Greek courts refused to send a question about the Turkish deal. It couldn't be challenged directly. The Greek courts wouldn't send a question to the EU court about a more direct challenge. So it survived, but it only survived as long as Turkey was willing to apply it, right? Once Turkey refused, in principle, it can't be applied anymore unless you could convince Turkey to change its mind. And who knows, what kind of deal might be done to do that, but you never know. So that's how these things survive, but it's qualified to say they survive. Yes, there's a deal with Libya, in part that survives because the European Court of Human Rights has given one of its more conservative judgments on immigration just during the last few months. It said that when Italy contacts Libya and coordinates to hand people over to Libya, or for Libya to take charge of them, Italy can't be responsible under the ECHR. So a lot of asylum groups thought, well, there should be responsibility directly liaising with the Libyans to take over them. The Libyans won't protect their human rights. Surely you've got responsibility there. But the Human Rights Court said no. I mean, this does look like a case in which they might be reacting to the criticism of the court for being too liberal. Now, of course, the critics of the court have not even paid any attention to this, right? And, it's not even on their radar. God knows what you'd have to do to get their attention, convince them. Maybe nothing would convince them that the Human Rights Court is now restrictive enough for them. So, like I say, though, maybe those pushbacks cases coming next is an opportunity for the court to even more dramatically try and convince states that it is being more conservative, if it wants to take that route, and rather than perhaps accelerate the dispute that it's having with them over how liberal it is.
I'm going to try and take your question in conversation afterwards, if that's okay, because I note from the time that I have gone over. I want to thank you all for the brilliant questions. I want to thank the panelists for sharing their research, and I want to thank Paul, Craig, and Billy again for inviting us all to write on this.